Yes, call the list. Pass over. Pass over. 5. Yes, the matter is already admitted. Is it admitted? Is there any caveat? You are for the caveat? Okay. So anyway, let the petitioner's advocate come. Pass over.
Lordship, right, number 6, my learning senior will update tomorrow, thank you.
Not today.
Okay.
Number 7.
My lord, may I have October 30th?
Pass over. I have passed it over, just a minute. 8. Yes, pass over. 9.
Yes, the service is not complete due to the address
The
not
direction for service.
Yes, my lords. But address not located. It has been returned.
So you can serve the lower court advocate.
Lower court advocate, my lords.
Yes, record an order. Learned advocate for the petitioner is present. It is submitted by the learned advocate that service could not be completed due to insufficient address. The petitioner is granted time to take fresh steps for service as well as serve the learned advocate appearing in the trial court.
In the trial court, my lords.
You want to, yes, file the copy of the envelope?
Envelope.
Yes, returned envelope.
It has been returned. This
Yes,
envelope
let
is
the
returned.
return envelope file be kept with the record.
My lords, I'm filing right.
Yes,
Amanam Dich.
yes. Let this matter appear in the next circuit.
Next circuit, my lords.
Let this matter appear in the next circuit.
Yes, sir. Giving. Ajay. Grateful, my lords.
Okay, 10 short pass over. 11. Yes. 11. Yes. You are for the petitioner. There is no caveat. Yes. What's the matter about? Yes, give the records. Yes, this is the refusal to pass ex parte ad interim injunction. And that is confirmed in appeal. Appeal is pending. Yes, let me see the trial court's order. Page 72. Was what for? Declaration and injunction. Appeal is pending. Yes, record an order. Learned advocate for the petitioner, plaintiff is present, or learned advocate for the petitioner. This application is directed against the, yes. No, no, was there any direction for service? Yes. There was a direction. Yes, where is the affidavit? Okay. None appears for the, when did you serve? No, when? No, when? It is delivered. Okay, none appears for the respondent in spite of service of notice. Let the affidavit of service be kept with the record. Learned advocate, it is the contention of the petitioner that the learned trial court and the appellate court have refused the prayer for ad interim injunction. Stop. The suit filed by the plaintiff petitioner was for a declaration and permanent injunction. Upon perusing the order passed by the learned trial court and appellate court, and considering the nature of the suit, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued once more upon the opposite parties and affidavit of service be filed. Let this matter appear in the next circuit, pending hearing of this application. The opposite party defendant is restrained by an order of injunction from disturbing the position of the petitioner with regard to the suit property for a period of 4 weeks. Yes, that is always there. Yes, Passover. Yes. Okay, not this week. Yes. Okay, not this week. Passover. Passover. Yes, Passover. Okay, not this week. Yes, 20. Yes. Where is that order? Let me see that. Item 20. Yes, record an order. Yes. Yes. It will be taken up. Let the mediators report come. Learned advocates for the parties are present. Yes. Oh, you want a change of the mediator? Yes, what is the ground? So the mediator has to be heard out then. Serve a copy upon the mediator then. Learned advocates for the parties are present. There is no report received with regard to mediation proceedings. In the meantime, one of the party that is respondent has filed a petition for change of the mediator. Let a copy of this petition be served upon the learned mediator. Let this matter appear in the next circuit. Yes, pass over. Yes, 21. Okay, pass over. Yes.
Filed by the respondent husband.
Yes, and in the opposite party you are. Yes.
Now, nothing. So matter, there are several disputes which have been offered, resulting from the matrimonial dispute regarding, so what happened? So they are matrimonials which are pending itself in the mark. Now both the petitioner and the respondents are the residents of the market. And they are the high school teachers.
Same school or different school?
No, different school. Now, what happened, Your Honor, the petitioner is the assistant teacher of the high school, which is situated as Malta. And from there, he is also one child has been the disabled child has been adopted. And he is living with his mother. Now, what happens? Several disputes are lying within the jurisdiction of the mother. Now, this respondent husband, what can be found? There is one flat, only one flat which has been comes under the children. He takes partition in respect of the death of the children. Now, I am staying at Malta, all the proceedings are staying there in the Malta. Despite the fact, he has, in order to harass as far as partition for him.
Now, where is the property situated? So, normal jurisdiction.
Just one property is situated in Chilko.
Yes.
All the other proceedings, all the other.
Properties are situated where?
All the.
How many properties are there?
I have to be particular of property. They are and you know, for the school is concerned, the whole.
And where do you reside? You reside at Malda?
No.
You reside at Siliguri?
I don't have a hard copy.
No, other suits are pending in which district?
Other suits they are.
এটা তো পিটিশনার হাই হয়েছে
Partition of suit between whom? Partition between the co-sharers.
Between me and the my tenant,
They are the husband. Lordship, both are teaching in the within the Malda district in the different school. Kindly, Your Honor, kindly consider para 2.
Paragraph you have stated.
Para 2. Para 2 of my petition. You know, at the bottom second line. All the properties are there in the Malda. They have separately only one property seeking in respect of the same flat in the Siliguri. The partition has to meet within the in respect of all the properties, and all the properties are situated. No.
But ultimately you cannot succeed
Yes.
until you bring all.
Yes.
Your suit will fail.
No.
You see, in a suit for partition, you have to bring all properties. Otherwise, your suit will fail.
Only one property. Partition.
No. But it's not that it is only one property of which the parties are co-sharers. If their parties are co-sharers of other properties, under the law, you have to bring them under the same suit.
Yes, Lordship.
Otherwise your suit will fail.
Lordship. No, that will not come under the partition suit.
No.
Immovable property is sales of goods.
Is there any other immovable property at Malda?
No. There is, Your Honor. Kindly see.
That property?
Kindly see, Your Honor, Lordship. At para 4.
Yeah.
The petitioner, if Your Honor, Lordship, may I, the petitioner states that the petitioner and the opposite party are joint owners of the two flats. One being flat number G measuring such and such at Rani Danga, Pashidava, which is situated in Darjeeling district, and another which is situated in district Malda. They are the joint.
Your affidavit in opposition to this. Yes, record an order.
So one mediation was made between the parties.
Mediation was there.
Mediation was been made before the honorable court, but that has already failed.
It
So
was sent to mediation.
yes.
Yes, learned advocates for the parties are present. Learned advocate for the opposite party prays for time to file affidavit in opposition to the application under section 24 of the Code of Civil Procedure. Such prayer is allowed. Let affidavit in opposition be filed within 2 weeks, reply within 1 week thereafter. Let the matter appear before next Sunday.
Lordship, kindly be seeking stay one of that said procedure.
When is the next date? Okay, fixed.
23rd
23rd
of December.
As the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
I'm for the petition.
I am appearing on behalf of the opposite party plaintiff, my lord. I am praying leave to appear online, my lord.
Matter is led by Lordship Senior Advocate Shiva Chief. Praying for Lordship Friday.
Yes.
Praying for
My
Friday.
lord, one indulgence before your lordship, my lord. Senior counsel Shaptangshu Basu will be appearing on behalf of the opposite party plaintiff, my lord. He will be appearing in person tomorrow, my lord. In that event, my lord, kindly adjourns the matter for tomorrow, my lord.
No, your learned friend is seeking for Friday. The other.
My lord.
Both
My lord.
appears from the Kolkata. Both appears from the.
Okay, let this learned advocates for the parties are present. On the prayer of learned advocates, the matter be fixed on 19/12/2025.
19th.
Friday is 19.
Oh,
My lord, Friday it will be difficult, my lord. Kindly keep it tomorrow, my lord. Let my learned friend speak at.
No, the others will not be available.
My lord, let he seek adjournment tomorrow, my lord. In presence of the senior council, my lord.
so Monday, then if they have difficulty in Friday, then
My lord, let it be tomorrow. My humble submission to your lordship. Let it be
Yes,
tomorrow.
Not today, tomorrow I shall consider. Acha, can you
My-
let it? Not today.
Deeply obliged.
Huh? Pass over.
One day.
Not today. 25. 25, you are,
And for the petition.
okay, 25, not today.
No.
Yes. I need to 24, I am this one, one day. Okay, 24, not today.
25, I'm praying for not today.
25, not today, yes.
Not today.
Next,
My lord, for this week.
25 you want not this week? Okay, 25 not this week.
That's clear.
Yes, pass over. Yes, next.
39.
Yes, call the passover matter. Both sides present. Any passover matter? Item 5, both sides present. Yes, all 29, 30.
Item number 4, my lord. My lord, this is appearing for the first time. Item number 4.
Item 4.
Item number 4, this is appearing for the first time. This is my application under section 24 of the Civil Procedure Code for transfer of a proceeding. My lord, this is appearing for the first time.
Let me see.
My lord, this is with regard to transfer of a custody matter pending before the district judge at Darjeeling
Yeah.
to the any court of Shiliguri, because my lord, other proceedings are, my lord, pending before Shiliguri. There are several proceedings instituted by either of the parties, my lord.
Okay, serve and come.
My lord, my lord. And in the meantime, my lord, I am praying for a short interim order, limited interim order.
Learned advocate for the petitioner is present. This is an application under section 24 of the Code of Civil Procedure filed by the petitioner for transfer of the suit from transfer of
My lord, Act 8 custody.
an application under Act 8, case number 17 of 2024, pending before Learned District Judge at Darjeeling to the Court of Learned District Judge at Jalpaiguri or any other court of competent jurisdiction. Stop. Heard learned advocates, let notice be served upon the opposite party, then convict and affidavit of service be filed. Let this matter appear before the next circuit. Stop. As this matter is sub judice before this court, the parties may seek adjournment before the learned trial court, which may be considered.
Grateful lordship. Grateful lordship.
Yes. Item 5. Yes.
There is a table. Other part is very much.
Yes, you are the petitioner.
I am the petitioner in this application, Lordship. Lordship, the suit has been instituted by the other side before the Learned Civil Judge Junior Division, Jalpaiguri.
Yes.
I have annexed the copy of the plaint, page number 14.
Yes.
In that suit that has been initiated by two sets of plaintiffs, that is, they are the opposite parties in this application, against the petitioners, that is the defendants in the court below, sued for declaration, injunction and consequential relief. Please, Lordship, come into the para number 2 of the plaint, that the plaintiffs become absolute owner in possession of a plot of land at measuring approximate 16.5 kathas or 27.5 decibel, comprised in forming part RS part number 6 appertaining to the RS Khatian number 601 within Mauja Dabgram such and such Bhaktinagar, previously under Rajganj, now police station such and such, by virtue of a deed of conveyance being deed number 22 for the year of 1994. So by virtue of this deed, the plaintiffs in the court below acquired the property measuring about 16.5 kathas. Please come into the schedule of the suit property. Page number 18, my page number, running page 18.
Yes.
So the entire land is 16.5 katha. The suit has been instituted in respect of the land measuring about 2.14 kathas.
Yes.
So why 2.14 kathas? That has been indicated in the para number 3 of the plaint. Please come in the para number 3. That thereafter the plaintiffs have transferred parts of the plot of land out of the total land 16.5 kathas as stated above in favor of several purchasers, and at present land is measuring 2.4 kathas is now in the hands of the plaintiffs and in course of time. So save and except 2.14 katha, that is the suit property, entire land has been sold and transferred to the various purchasers. But who are the purchasers and what the amount to the each purchaser, that has not been mentioned. Okay, no problem. Please come into the another document which I have been annexed. Come into the page number 42. Running page 42.
Yes.
I could gather the another plaint instituted before Civil Judge Junior Division Jalpaiguri in the same court, that is the title suit number 164 2021, one of the plaintiff Nipen Sutrodhar against one of the defendants Shobuj Kanti Das. Please see the para number 2, same deed, sale deed number 22 dated 4/1/1994, same also relied in that plaint also. Here the suit property is, suit has been filed for 4 kathas, 5 chotak. So in the previous suit, the plaintiff, one of the plaintiff, filed the suit against the one of the defendant, relying the original sale deed same.
Now the question is, see, The order of injunction passed by the learned trial judge is a contest order or ad interim order?
Contested order.
So the appeal is.
After my appearance, after filing the written objection,
No, you are for the defendant.
defendant,
Okay, defendant petitioner.
defendant
The application for injunction was disposed on contest.
on contest.
Okay. So thereafter appeal was preferred by the opposite parties.
No,
Oh, appeal was preferred by you.
I prefer the appeal.
So what was the order passed by the learned trial court?
Yes, Lord. Before that, if I will go to the.
No, because you see, entire thing was decided on.
No, that cannot be, Lordship. Yes, I agree.
Yes.
I am,
What is the order
I'm summarizing,
passed?
I'm summarizing.
What is the
Lordship, please come into the first order. Come into the first order. That suit has been dismissed for default.
So questioning, see, a suit in which this interim order is under challenge, that suit, that interim order was passed on contest. So
No.
let me see the order of the trial court first.
Page number 54, Lordship. Learned trial court, civil judge junior division judge.
Yes. There was a direction to maintain status quo.
Status quo, but that
Okay.
is giving me the trouble, Lordship. If there is no prima facie case has already been held by the junior division Jalpaiguri, after relying the documents as placed by both the parties, that the plaintiffs are not in the position at the time of the institution of the suit, they are not in a position to identify.
But let me see what is the order passed by the appellate.
Same order, Lordship. By modification, same order.
But not satisfied with the order passed by the.
Yes, Lordship, that the
So
status
you
quo
want
order
the-
in any
You
manner.
want the order to be thrown out, entire application to be thrown out, injunction application. No protection should be given.
No, no, Lordship, I am not saying that. That the golden rule for getting the injunction from the court in respect of the injunction, where is the prima facie balance of convenience and the irreparable loss and injury?
Sufficient reason is given, that much protection should be given.
Lordship, first one, they are not in the possession at all it is the findings of the learned court below. If the court holds that I am in the possession, thereafter the status quo order is given, there is no problem.
The learned district, the appellate court has clarified, whoever is in possession, that should not be disturbed. What is the order of the trial court?
See, let's see again, please.
Let me see the order of the trial court is status quo.
Status quo after when? After holding that the plaintiff.
Yes, I didn't pick it. Only thing is this, the documents are not furnished with regard to the title. Yes, partition make status.
Lordship, what is the findings? Please see. Please see the second paragraph, Lordship, second paragraph of that order, page number 54.
Yes,
Should I read?
yes.
The,
No, I'm going to the.
okay, Lordship. It's very vital. Second paragraph, third paragraph, fourth paragraph also.
You give us that after passing this order, they are disturbing your possession.
See, already several cases they started, police case started. Oh, these plaintiffs misleading the order of the district court. This is unnecessary harassment, Lordship. Why I will face all these things? By virtue of the registered sale deed, I acquired the property. Maybe once upon a time they hold some property, but they don't know where the property is there.
Yes.
An application under deliberately violated the judgment passed by the honorable district judge. If the status quo order, that is my only protection.
When did you prefer this appeal? That is,
After the order has passed, contested order has passed by Learned Civil Judge Junior Division.
so this is subsequent to the. preference
Yes,
of this
Lordship.
appeal.
Yes.
The issues in the main system already been.
Learned trial court, if it is hold that I am in the possession, that the plaintiffs are not in a position to identify the proper suit property. So, okay, if I am in the possession, it is the findings of the learned court. Thereafter, if the status quo order is there, I have no problem.
That means you see, everybody has produced the documents regarding to title and possession. Over a share in the suit property, okay, prima facie, title and possession over a share in the suit property. Not entire suit property, okay?
No, I'm not saying that the entire suit has already been concluded. Only
No.
the thing that,
Defendants are prima facie, title and possession over a share in the suit property. Suppose whatever is the suit property, he is claiming absolute right title, But defendant has also some right.
Yes,
That has to be protected also.
yes.
Time of a case should not become title. Title will be.
Now, who will determine who is in the position? I am stating that I am in the position.
Yes, record and order.
After the trial, the
Learned advocates for the parties are present. Learned advocates for the parties. This litigation under Article 27 of the Constitution of India is directed against judgment order dated 26th day of September 2025, passed by Learned District Judge Jalpaiguri in miscellaneous appeal number 17 of 2025. Stop. By the judgment dated 26th day of September 2025, the Learned District Judge being the appellant was pleased to modify order number 11 dated 22/5/2025, passed by the Learned Civil Judge India Division, Jalpaiguri, in title suit number 11 of 2024 in favor of the plaintiffs stroke respondents. By the said order, the order passed by the Learned Trial Court was varied and modified. The suit was filed by the plaintiff respondents for declaration and injunction. Stop. Filing of the suit and for temporary injunction was filed by the plaintiff, which was cited by the Learned Trial Court. Yes. Learned Trial Court by order dated 22/5 was pleased to observe and direct response in the court of folded page. The defendant being aggrieved, defendant petitioner being aggrieved, preferred an appeal the appellate, which was disposed by judgment dated 26th day of September 2025. Upon perusal of the judgment dated 22/5/2025, it appears the Learned Trial Judge has observed that both the plaintiffs have the LR record of rights in their name, which has a statutory presumption of correctness. And it is further observed that the defendants have also filed the original title and changed it and the LR record of rights in the name of defendant number 2 and also Khajna Takila. Stop. The Learned Trial Judge, although did not pass an order of injunction restraining the defendants from entering the suit property, but have only directed the parties to maintain status quo as regards the title position and their respective positions of the property. Stop. The order of the Learned Trial Court was modified by the Learned Appellate Court by observing that status quo in respect of position means the person or persons who are in possession in the suit property at the time of granting ad interim injunction in the finality shall remain in possession without any interruption or interference from either of the sides. learned judge appellate court was also directed to observe that the order of status quo, so far as the nature, character, and position was the suit property, as on this date, has to be followed by the parties of the appellate's carry. Thus, both the learned trial courts and the learned appellate courts have assigned reasons to come to the conclusion with the grant of interim order. As before passing interim order, the balance of convenience, exigency, and irreparable loss are taken into consideration. Under facie, it appears that both the courts have taken care of this aspect before passing this order. Stop. Learned. Thus, considering the facts of the case and considering the order passed, this court is of the view that there is nothing perverse in this order, and hence there is nothing to interfere. As learned advocate for the petitioner submits that pursuant to the order of status quo passed by the learned courts, the plaintiff appellant have instituted false case and have caused disturbance. Stop. In the event there are subsequent developments by which the defendant is aggrieved, and there is also grievance with regard to the disturbance of possession, either of the parties may apply before the learned trial court for appointment of commissioner to ascertain the present position of the parties and subsequent events. In the facts and circumstances, this revisional application stands disposed by affirming the order passed by the learned appellate court, being miscellaneous appeal number 17 of 2025, passed by learned district judge Jalpaiguri. Yes, disposed. Yes, next.
I don't know, 10. 10. Third, 10.
Item
10.
yes, 10. The appearing for the first time.
No, the notice service order was there. I have complied. Impound order dated 6/11/2025. It is annexed last.
Yes. Okay, not today and tomorrow.
Deep level.
Twelve 30,
Item number 29, praying for not today, my lord.
20?
29, my lord.
Okay, not today.
Great.
Item number 1, I'm praying for not today. Yes, not today. Yes, call 30.
Item 1. Lordship, item number 27, I'm praying for not this week, Lordship.
27.
Lordship.
When you mentioned tomorrow, I've just passed it tomorrow.
Grateful, Lordship.
Yes, call 30.
Lordship, item number 28, and for the petitioner. Lordship, kindly praying for next circuit, my lord. There is a talk of settlement going on between the petitioner and the planner.
28 record and order. Learned advocate for the petitioner is present. On the prayer of learned advocate, the matter stands adjourned till the next circuit.
Item 30.
Yes, next.
31.
You want record the key? Not today.
32.
Yes. Not today. Yes. You are for the appellant insurance
I am for the
company.
appellant.
Appellant insurance company.
Yes.
Okay, can one is your application?
Yes.
Yes, let me see. Can one is for stay?
Yes, stay. Appeal has been filed within time.
Yes, have you deposited the statutory amount?
Yes, yes.
Where is the deposit slip? The statutory amount or the entire awarded sum?
Statutory amount.
Yes, let's see. Yes, record and order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory sum of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 26 September 2023, passed by the learned additional district judge, third Special Court, Jalpaiguri, in MSCC number 177 of 2011 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court within this period of 5 weeks. Stop. In the event such deposit is made within this period of 5 weeks, the ad interim order of stay of the judgment and award passed by the learned trial court shall continue till disposal of this application. Let this, yes, liberty to mention. Liberty to mention after making the deposit. Can one stand disposed? No, can one stand pending? Yes, pass over,
35,
pass over.
36,
36, 30. Okay, not today.
thirty-seven,
Again. Not today. You have got the appellant insurance company? Yes. You have deposited the statutory amount? 25,000 is the statutory amount. Have you taken out any application for stay? Yes?
Admission.
No, it is within this period of limitation.
Execution proceeding is running with the tab.
But you have to file a formal stay application, otherwise how a stay can be granted?
Adjournment could allow adjournment.
But you have deposited the statutory amount. Yes, file that. Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has filed the statutory amount of rupees 25,000. The appeal is admitted and there shall be an ad interim order of stay of the judgment and award dated 3rd day of May 2025, passed by the learned additional district judge, 3rd court, Kuch Bihar, in 3rd court in charge, Kuch Bihar, in MSC case number 26 of 2019 for a period of 5 weeks. The appellant is granted liberty to take out a formal application for stay. Stop. It is however made clear that in the event the appellant deposits the entire awarded sum along with interest as directed by the learned trial court, there shall be a stay of the judgment and award passed by the learned trial court till shall deposit the entire awarded sum within period of 5 weeks. Entire awarded sum excluding statutory amount within the period of 5 weeks.
My lord, can you make it more?
No, 5 weeks is sufficient. All cases are passing 5 weeks. The judgment and award shall remain stayed till disposal. Okay, the judgment and award shall remain stayed for a further period of 2 weeks. Unless you see, you file an application, I cannot say till the disposal of this application. Anyway, liberty to file application for stay and thereafter mention.
My lord.
So you have deposited the statutory amount. Okay, the claimant. So it is filed within the period of limitation. Yes, record an order. Learned advocate for the appellant is present. As this appeal is filed within the period of limitation. Learned advocate for the appellant is present. As the appeal is filed within the period of limitation, the same is admitted. Let notice be issued upon the respondents within 1 week. An affidavit of service be filed. Let this matter appear in the next circuit. Not today.
41,
Not today.
42,
Not today.
43,
Not today.
44,
Yes.
Lordship, I'm praying for not today.
Okay, not today.
45,
Short possible.
Okay, short pass over.
46,
You are for the appellant insurance company. So have you deposited the statutory amount? Anyway, I'm just making it not this week. You deposit the statutory amount. And thereafter you make an application for stay, not this week. Same, and not this week? Yes. Where is the application for stay? How I can stay the entire award without any application? Anyway, give this so. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount, the judgment and award dated 1/9/2025 passed by the learned additional district judge, Third Court, Jalpaiguri, in MSC case number 383 of 2019 shall remain stayed for a period of 5 weeks. The appellant is granted liberty to take out a formal application for stay. In the event the appellant is the appellant shall take steps to deposit the entire awarded sum within the period of 5 weeks. as directed by the learned trial court, which will include the interest. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue for a further period of 2 weeks, and in the event an application is filed, till the disposal of the said application. Liberty to mention. Yes, take out a formal application and mention. They give 48. Yes, statutory amount you have deposited, yes, file that. Or if you have a Xerox copy, you can file that also. Learned advocate for the appellant is present, as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 31/7/2025, passed by the learned additional district judge, Fast Track Court, Kuch Bihar, in MSC in MSC case number 23 of 2014 for a period of 5 weeks. Stop. The appellant, yes? No. It's stated 2014. Okay, 23 of 2024. MSC case number 23 of 2024. The appellant is directed to deposit the entire awarded sum along with interest as directed by the learned trial court within the period of 5 weeks. In the event the entire awarded sum along with interest is deposited within 5 weeks, the ad interim order of stay shall further continue for a period of 2 weeks, subject, and in the event an application for stay is filed, the same order shall continue till disposal of the application for stay. Liberty to mention. And yes, not today.
Lordship, in item number 50, I'm appearing for the appellant insurance company, Lordship. Lordship, we are required to file the stay petition, Lordship. We need some time to file the same, Lordship. Kindly keeps it on coming Monday, Lordship. I'm
Okay,
praying for not this week, Lordship.
Not this week.
I'm grateful, Lordship.
51. Not today. 52.
My lord, I am on behalf of the appellant claimant petition. My lord, the case is filed within period.
So serve notice upon the opposite party. Yes, record an order. Learned advocate for the appellant is present. As the appeal is filed within time, the same is admitted. The appellant shall serve notice upon the respondents within 1 week and file affidavit of service. Let the matter appear in the next circuit.
Grateful.
First time appearing in the list, let there be direction to file the memorandum of appeal before the respondent.
Question is, service upon the respondents are complete.
No, sir, there is no direction. For the
Yes,
first time,
record an order.
for the first time it is
Learned
appearing in the list.
advocate for the appellant is present, As the appeal is preferred within time, the same is admitted. The appellant shall serve notice upon the respondent within 1 week.
Lordship, on indulgence.
Yes,
OP number 2, that is the owner of the dispensary. That
yes,
is
yes,
not,
all. Serve notice
and
upon
is
the
not
respondent.
contested in the lower court.
Maybe. Serve note within 1 week and file affidavit of service. Let this matter appear in the next circuit.
Lordship, 54 and 55, the same matters, corrected matters.
53 and 54.
54 and 55.
53, 54. Okay, 53, 54, 55, same as 52.
Same.
Same order as 52.
Get full, Lordship.
Six. Yes, not today.
57,
Not today.
58,
Not today.
59,
Same, not today.
60,
Not today.
61,
Not today.
62,
Same.
63,
Yes, same order.
64,
Yes. What is this can one? Can one have you served? Okay. So can one have you served? First section 5 has to be allowed. Thereafter, that stay will be taken up. Have you served can? So without serving. Let me see. Yes, you are appearing.
Yes, I am on behalf of the respondent claimant.
Respondent
there-
claimant, that means in your learned friends matter.
Yes.
Okay, so appear. So it's better, let me see
Actually,
the section
we
5.
have
Yes,
also.
section 5, how many days delay? Can one is section 5? Yes, let me see. Yes, I am allowing this condon.
Yes, Lordship. And there is another matter, we have filed another matter,
Yes.
being FMT MB number 65/20. Both the
counter
matters.
case.
Yes,
Counter case.
yes, both the matter is heard analogously.
Yes, record an order. Learned advocate for the parties are present. The application for condonation of delay being Can 1 of 2025, Can 1 of 2024 is taken up for consideration. Our learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that as the appellant has shown sufficient cause for the delay should be condoned. Thus, the delay in filing this appeal is condoned. Can 1 of 2024 is allowed. Yes. The other can 2? Yes. How much? Only statutory amount you have deposited? Yes. Let me see that. Can দিতে এখানেই আছে। Yes. 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 Can queer order. The learned advocates for the parties are present. As the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 12/2/2021, passed by learned additional district judge, the Second Court Siliguri, in MSC case number 38 within bracket 5 of 2017 for a period of 5 weeks. Stop. The appellant shall take steps to deposit the entire awarded sum along with interest within this period of 5 weeks. Stop. Oh, along with interest excluding the statutory amount within this period of 5 weeks. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. As the respondent number 1 have already appeared, the service of notice upon respondent number 1 is dispensable. The appellant shall take steps to cause service upon respondent number 2 and 3. Liberty to mention. Yes, any other application? pending?
Yes, Lordship. By,
No, no.
No, in this matter.
That is any appeal to be listed along with this one.
no.
Not today.
Lordship, I'm praying for not today.
Not today. Not today.
Lordship, I'm praying for not today.
Not today.
Yes.
Lordship 68, Lordship kindly taken up the matter on 18th, Lordship.
Well, for the insurance company?
Yes, Lordship.
Okay, not this week, 68.
Lordship 18th, Lordship.
Yes?
18th,
When?
18th.
Acha, record an order on the prayer of learned advocate for the appellant. The matter stands adjourned till 18/12/2025.
Yes, Lordship. Lordship 69, 70 same period, Lordship.
69 and 70, same date.
Yes, 73 also.
Acha, 69 also, call 69?
69,
Okay, same order.
70,
70,
same
Same
period.
order.
Hmm.
71.
Yes. Yes, keep it out. Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount, the judgment and award dated 26/11/2024, passed by learned additional district judge, Third Court, Jalpaiguri, in MSC case number 61 of 2015, shall remain stayed for a period of 5 weeks. Stop. The appellant shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial, excluding the statutory amount within the period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. It can one order. Yes, liberty to mention. হ্যাঁ ওটাতে লিখে দেবেন তাহলে একটা লাইন লিখে দেবেন the registrar requested to take steps to deposit the entire awarded the entire awarded sum in a fixed deposit of a nationalized bank and renews the same from time to time. সবগুলোতে তাহলে লিখে দেবেন So why defective? Is defect here? Okay. Record an order. Learned advocate for the appellant is present as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be a stay of the judgment and award dated 9/12/2024 passed by learned additional district judge Alipurduar. Learned additional district judge second court Alipurduar in MSC case number 7 of 2022 for a period of 5 weeks. The appellant shall deposit the entire awarded sum as directed by the learned trial court along with interest, excluding the statutory amount within this period of 5 weeks. Stop. In the event the entire awarded sum along with interest is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. A liberty to may mention, let the note defective be removed from the cost title.
Lordship, same prayer as 68, Lordship, on 18th.
68.
Yes.
73, same order as 68.
নাম দেওয়া আছে।
24. So who is from the appellant? You are the appellant? Can one is for what? Yes.
Evidence submit the
2,385 days later. 2,385 days. When it was passed? It was passed, Lordship, 2018, Lordship. 6th of June 2018, Lordship. You have received part of the sum which was awarded.
Lordship.
Yes, record an order. Learned advocate for the appellant and learned advocate for the respondent number 1 insurance company are present. The application for condonation of delay is taken up for consideration. Heard learned advocates. Learned advocates for the appellant submits that due to the COVID period, the appeal, this application could not be filed. Appellant has further submitted that the appellant is from the weaker section of the society and was not aware about the order passed, thus the judgment, thus the delay in filing this appeal be controlled. Learned advocate for the opposite party, learned advocate for respondent number 1, insurance company objects the prayer upon considering the facts of the case and considering the fact that the motor accident claim are welfare legislations. In the interest of justice, the delay should be controlled and the petitioner should be permitted to prefer this appeal. Thus, I condone this delay in filing this appeal. Can 1 of 2025 stand dismissed. As respondent number 1 has already appeared, service of notice upon respondent number 1 is dispensed with. Let service of notice be effected upon the other respondents. Service of notice be effected upon the other respondents. Liberty to mention.
And LCR will call for lordship
Okay, trial court's record be called for.
and paper book lordship.
The paper,
Informal.
liberty to mention after the trial court's records come.
Lordship.
Thereafter, direction will be given.
Lordship. I'm for the petition.
Why is this defective?
Yes, sir. Lordship, the condonation of delay, lordship.
Have you filed that?
Yes, lordship. Can one lordship.
How much is the delay?
2,429 days.
The appeal was filed when?
Lordship, 2020,
2000?
5 lordship, in March, lordship.
Have you served a copy of section 5
Yes,
application?
yes, sir. Lordship, explanation is that lordship, only in explanation, lordship, the para number 8, lordship, 8
You
to
want
14, I
file
have.
opposition, file it within this week. I shall take it up next week. Yes, record an order. I'm giving you this week. I'll take it up next Monday. Yes, record an order. Learned advocates for the parties are present. Learned advocate for the respondent number 1 insurance company praised for leave to file an affidavit. Such prayer is allowed. Let affidavit in opposition be filed on or before 22/12/2025. Let this matter appear on 23/12/2025.
Get it.
I'm for the appellant. This is statutory deposit receipt.
Record the Yes, record an order. Learned advocate for the appellant is present as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 19 December 2024, passed by the learned additional district judge, fast track Additional district judge. First track court Kuchbihar. In MSC case number 7 of 2014 for a period of 5 weeks. The appellant shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the judgment and deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within the period of 5 weeks. In the event such deposit is made within the period of 5 weeks, the judgment and award of the learned trial court shall remain stayed till disposal of this application. Liberty to mention. The disposal of order. Yes.
Petitioner.
Okay.
What's the petitioner? In this, we have filed appeal on behalf of the company.
Can 1 and can 2.
Can 1 is, there is a delay of 15 days.
Yes, can 1 and can 2 is stay.
Lordship.
Yes, record an order.
First, stay or something, depending amount.
No,
Yes,
no,
yes.
Statutory amount you have deposited.
Deposit.
Yes, record an order. Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates. Peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellant has shown sufficient cause for condoning the delay. Thus, delay of 15 days in preparing this appeal is condoned. The appeal is thus admitted. Can 1 of 2025 stands disposed. Stop. Can 2. In the instant appeal, learned advocates for the parties are present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 5/12/2024, passed by the learned additional district judge, first track, first court, Alipurduar, in MSC case number 23 of 2029 for a period of 5 weeks. Stop. The appellant shall take steps to deposit the entire awarded sum along with interest, excluding the statutory amount within this period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Yes, liberty to mention. Can want a disposal or put up pending.
Okay, 79.
Lordship praying for 1 day accommodation, 78.
Not today.
Lordship, kindly fix the matter on 18th, Lordship.
Yes, let this matter appear on 18/12/2025.
On behalf of respondent number 2, paying for accommodation Lordship, for 1 day.
Okay, not today.
Lordship.
Lordship, same prayer on 18th, Lordship.
Let this matter appear on 18. That is item 82.
Yes, Lordship.
Let this matter appear on 18/12/2025.
83. Same prayer, Lordship.
Same order.
Same prayer. Lordship.
Same order.
85.
Not today.
Lordship, I pray
85?
for 85.
Okay, not today.
Yes.
86.
Lordship on 18th.
86 will let this matter appear on 18/12/2025.
87 and 88, same prayer, Lordship.
87 and 88 also the same order.
89.
Yes.
Lordship, I'm praying for not.
Okay, 89 not today.
Pray for Lordship.
90.
Not today.
91.
91, I'm applying for the appellate.
What is the
my lord.
defect?
For the defects, my lord, Lordship, kindly allow me to, my lord, see the defects so that I can clear it.
See.
My lord, one more thing is, my lord, the appellant, my lord, he has.
You are
expired-
for?
I'm for the appellant, man, appellant plaintiff. My lord, the appellate Lordship, he has expired.
No, is the matter admitted?
No, not admitted. My lord, it's an order. It's a second appeal.
So why it is before the single bench if it is not admitted?
That I also, my lord, cannot understand, my
Is there
lord.
any section 5 application?
My lord, I have not yet filed the section 5 application.
No, question is, you see,
Yes, yes.
In
First,
case
it
of-
will be admitted under order 41 rule 11.
it is
Yes.
already admitted.
Not admitted, it has never come to the
No,
list,
you
my
see,
lord. Not
after admission, this matter comes to single bench. Only in case of section 5, it is to be heard by the single bench, thereafter sent.
What happened before filing the section 5 application, Lordship, what I have gathered, the appellate Lordship, he has, my lord, expired
You
very
see that
recently.
fact, you see. First of all, condonation of delay is not filed.
Yes, your lordship.
Second thing is this, name of the pro forma respondent number 6 does not tally with that of the degree of the appellate court. The date of signing of the degree may be deleted from the preamble of the grounds of the bill. Anyway, you take steps,
Because, my lord, the appellate plaintiff, my lord, he has expired very recently.
take steps also for
Yes,
that.
lordship.
Whatever is this, whatever is the defect, you take steps.
Yes.
Yes, record an order. Learned advocate for the appellant is present. Learned advocate pressed for time to take necessary steps to remove the defect. You want in the next circuit?
My lord, yes, my lord,
Yes.
substitution has to be
Yes.
filed.
Let the defect be removed and liberty to mention in the next circuit.
Lord. May I
Yes, yes.
go through the, my lord, the defects of the.
Ninety-two, yes.
Kindly fix this matter on Monday.
Okay, not this week.
Yes, Lordship.
93.
Not today.
94.
Lordship, I'm praying for not this week, Lordship.
Okay, not this week.
94.
95.
Not today,
96,
not today.
97,
Yes, 97.
I'm requesting for not.
Okay, not today.
98, for the opposite party number one.
It is not here. Right? Not today.
99,
Not today.
100,
Not today.
101,
My lord, kindly day after tomorrow.
Okay, not today and tomorrow.
I'm for the opposite party.
Okay. Revisional application.
It's practically I am opposite party is recalling petition, but I was the original petitioner in the original.
I'm just making it not today.
My
Not
lord,
today and tomorrow.
day after tomorrow, my lord, Wednesday.
I have taken off the ground of the original, yes, and thereafter also, that will be taken from the record. Let the matter be fixed as a last.
Anyway, I'm just making it not today, tomorrow. On the next day, I shall pass necessary order.
Grateful, lordship.
102,
Yes, the matter is ready for hearing.
Yes, Lordship.
The paper books have been filed.
Yes. Lordship,
Okay, you are for the Oriental Insurance.
I am for the respondent number 1, 2, and 3, Lordship.
Let me see what is the matter about. Can one is disposed?
No, Lordship.
Can one for?
For stay.
Can 2
Have you deposited the entire awarded sum?
No.
So there cannot be a stay. No. Question is, you have deposited the statutory amount. So if you deposit, I am granting you time for 5 weeks. You deposit and thereafter you mention, yes, record an order. Learned advocates for the parties are present. No, you, after depositing the statutory amount, there was a stay for a limited period.
No, nothing.
Yes, did though it a record. What is the deposit? Okay. Yes, record an order. Learned advocates for the parties are present as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 10/4/2000. Judgment. Or judgment and award dated 6th day of July 2023, passed by the learned additional district judge, Second Court Siliguri, in MSC case number 20 within bracket 3 of 2018 for a period of 5 weeks. Stop. The appellant shall deposit the entire awarded sum along with interest, excluding the statutory amount, within this period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, there shall be the ad interim order of stay shall continue till. Have you filed any application? Okay, till disposal of this application. Liberty to make. কেমন আছে
টাকা দেবে তারপরে হবে। না, টাকা দিলে তারপরে।
Yes, if you deposit, it will remain state will disposal of this application. That- Not today. 104.
Lordship, I'm praying for not today.
Okay, not this week.
Not today.
Okay, not today.
Great Lordship.
Yes, not today. 107. Not today. 108.
For 1 day.
Okay, not today.
109 and 10.
Praying for 1 day.
Not today.
Lordship, in item number 109 and 110, I'm praying for not today, Lordship. 109 and 10, Lordship.
Okay, okay.
Grateful, Lordship.
7.
Not today.
112 and 13.
My Lord, I'm praying for not today.
Okay, not today.
114.
Not today.
And 14 and 15.
Same, not today.
116.
The matter is ready for hearing. What is this canvar? You are for the appellate.
I am for the respondent.
Mr. Mominur Rahman is for that.
So if you want, I can fix it tomorrow or day after tomorrow.
Monday.
Time will be very limited. You see, there will be three working days.
Friday.
Yes, that I can do. I can fix it at Friday at 2 p.m. To inform. Yes, record and order. Learned advocates for the parties are present on the prayer of learned advocates. Let this matter appear on 18/12/2025 at the top 2 p.m. Right. Not today.
118.
Okay, not today and tomorrow.
119.
Landlord response.
Is the matter ready for hearing?
Yes, ma'am. I am for the applicant, ma'am. Can you fix a date, ma'am?
I can keep it day after tomorrow if you want.
Yes, ma'am.
Yes, record and order.
Yes, ma'am.
Learned advocates for the parties are present. On the prayer of the learned advocates, the matter be fixed on 17/12. আগেরটা কত দিচ্ছি 18 আগে না না ওটা তাহলে ইয়ে ফ্রাইডে তো 19th হবে যেটা 18 বলেছে এইটা 19th হবে Okay, 18/12, Friday, Thursday I'm keeping it this one. 18/12/2025 at 2 p.m. Top. Ready? Yes. Was the appellant Clement? Yes. How much award was passed? So, 4,43,000. No, 4,43,000. And how much you claim? Okay. 4,46,000 is awarded. Yes, what is the ground of challenge? Yes? No, this was the case of which year? Yes, you have the paper books, please. Paper book it in. Yes, let me see. According to what evidence did you adduce regarding income? Yes? 2017 case. That is pursuant to that pronunciatory judgment. Okay, judgment is pursuant to the judgment, this pronunciatory judgment. Okay, now what evidence did you adduce with regard to income? Page 53.
My employer, computer more than 5 months.
Page 53. So what was your occupation?
I am the mason.
Mason. And what did he say?
He said that my income is rupees 300. Salary is rupees 6,000.
Mason, you are the mason?
Yes, sir.
Daily rated or monthly?
That is monthly.
Monthly. Yes, regarding future prospect, any amount taken? No, your ground of challenge is that instead of 3,000, instead of 6,000, the landed trial court proceeded on 3,000.
And another is that there is no interest.
No interest awarded. Future prospect, where have you taken that point, future prospect? Why? Yes. Future prospect is? No, did you claim that future prospect? Yes?
No future prospect is expected.
Yes.
Other point is that probably final very happy.
Is it a death case or?
Instead of interest in house as per permission.
That consortium granted?
For 9,500. 2,000 for criminal expense and knockout is still 2,500. Should be 70,000 and only 10% increase will be checked.
Yes, what do you say?
Another
171? Oh, interest was not awarded. at all. Yes.
So the case was filed before the potential thing. And it was rightly.
No, judgment was awarded. Award was passed after Pronacity.
But it was filed for the. And second thing is that there is no negligence on the part of the.
No, that the trial court came to the conclusion. Trial court came to the conclusion that there was negligence. He is not agreed by that. He is agreed by the quantum.
And first thing is that
Yes, where is that observation? There was no negligence by the trial court. It is not under 163A probably, 166. Yes, where is that observation? There is no negligence. Okay, so it is your contention.
I feel
Your plea is this, it is just and reasonable. Yes, the trial courts are. It's only your learned friend. Okay, 72,000. This should be, so 6,35,000 should be the compensation. Yes, record an order. Learned advocate for the appellant claimant and learned advocates for the respondent number 1. Insurance company, New India Insurance, Assurance Company Limited are present. Are learned advocates for the parties. The appellant before this court was a claimant in a claim case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 13th day of January 2017 in MACC case number 171 of 2015. Stop. The case of the claimant appellant may be summed up thus. Next. On 6/12/2014 at about 6 p.m. when the victim Gokul Bormon was proceeding towards his house with one cycle from Assam Mode. At that time, one truck bearing number WB-39/2681 coming with high speed rashly and negligently dashed the backside of Gokul Bormon near Poncho Hotel, Holdibari Mode, PS Kotwali, District Jalpaiguri. Stop. As a result, Gokul Bormon sustained severe injuries on different parts of his body and was admitted to Sodor Hospital, Jalpaiguri, from where he was shifted to NBMC and finally succumbed there due to his injuries. Stop. At the relevant time, the deceased was 39 years old and was a mason by profession having monthly income of rupees 6,000. Stop. The accident took place due to rash and negligent driving on the part of the driver of the offending vehicle. Stop. Over such accident, the complaint was lodged before the police authority and a case was started under section 279/304A of the Indian Penal Code. Stop. The respondent number 1, insurance company, appeared before the learned trial court and filed written statement. Stop. Issues were framed and the claimant appellant adduced evidence. Stop. Upon hearing the learned advocates and considering the evidence, the learned trial judge was pleased to dispose of the claim case by observing and directing as follows. Hence ordered, put page 26, that MSC case number 26, quoted page. The appellant claimant being aggrieved by the judgment and award passed by the learned trial court has come up with the instant appeal. Stop. It is the contention of the appellant that the learned trial court has considered the income of the victim to be rupees 3,000 and not rupees 6,000, although evidence was adduced by the employer of the victim in this regard. Stop. It is further contended that the future prospect was also not taken into consideration by the learned trial judge. Stop. And it is also contended that the learned trial judge did not award interest while computing the compensation. Learned advocate appearing for the respondent number insurance company submits that the judgment passed by the learned trial court is just and reasonable and it need not be interfered with. Upon hearing the learned advocates and upon perusing the evidence adduced, it appears that the claimants examined the employer of the victim and the employer adduced evidence wherein he stated that the income of the victim was rupees 6,000. Stop. There is nothing in cross-examination from which it could be derived that the victim earned less than 6,000. Upon considering the evidence adduced, this court is of the view that rupees 6,000 ought to have been taken into consideration as the monthly income of the victim. Stop. Hence, the monthly income of the victim could be considered as 6,000. Stop. Annual income comes to rupees 72,000. Stop. Future prospect of 40% added is rupees 28,000. Thus, total income is 1,08,000. 1/3, which comes to rupees 1,08,000 on account of personal expenses, shall be deducted from the total income, and it comes to rupees 33,600. 33,600. Hence, the annual dependency loss is rupees 67,200. As the victim was 39 years of age, the multiplier of 15 should be applied, and the total compensation comes to rupees 10,08,000. Stop. Apart from the claimants are also entitled to general damages on account of rupees 40,000 as consortium and 30,000 on account of funeral expenses and loss of estate. Thus, rupees 70,000 should be considered as general damages. Hence, the total compensation which comes by calculation is rupees 10,78,000. I'm just awarding 10 lakh as the courts have power, as the courts have power to award just and reasonable compensation. This court is of the view that rupees 10 lakh is just and reasonable compensation. Thus, the as 5,57,000 as the insurance company have already paid the awarded sum of rupees 4,43,000, rupees 5,57,000 should be paid by the respondent number 1 insurance company along with interest at the rate of 6% per annum from the date of filing till date of the deposit. The respondent number 1 insurance company shall make the deposit of rupees 5,57,000 along with interest from the date of filing till date of deposit, and along with interest from the date of filing till date of this order.
But 4 lakhs for interest part also.
Yes, definitely. Interest on 5,57,000. 5,57,000 plus interest from the date of filing till today. Date of filing till today. 5,57,000. Date of this order. No. Oh, interest. Oh, 4,43,000 interest is not awarded. Oh, then okay. Oh, they shall. 5,57,000 along with interest from the date of filing till date of till today. Further, interest of rupees 6% per annum on rupees 4,43,000 from the date of filing till today. No, only interest. Only interest with regard to 4,43,000. Interest of 43,000 from the date of filing till date of deposit till today.
Insurance company already deposited this amount. Because they have already withdrawn the amount. So that was 5 months.
But the question is this: is agreed by the non-grant of interest on 4,43,000. Now so far, this 5,57,000 is concerned, interest is being awarded. Okay. Now 4,43,000 is already paid without interest. Okay. So only thing is this: I am calculating the interest of 4,43,000.
The date of
I'm making it till today. Okay, just a minute. Oh, they have already withdrawn. Okay. They pay it from the date of filing of the claim case till date of deposit already made by the insurance company. The balance deposit before this court shall be made by the appellant insurance company within 5 weeks from the date of communication of the order. The appellant insurance company, the respondent number 1 insurance company, the appellant will be permitted to withdraw the amount upon compliance of all necessary formalities. Yes. This appeal stands dismissed. Just call the next. Okay, 121. Not today. Then 122. Yes, not today. Yes, not today. Yes, not today. 126, not today. 129, not today. Okay, call 125. 125. Yes, next, not today. 127. Yes. 127. So you are the appellant. Yes, where is the? Oh, this is a no. The matter is ready for hearing. So stay is there.
And it should have been already.
So what is the ground of appeal?
Part was buying without property. A chance to recover the amount.
See, with regard to that, I have passed a judgment. Anyway, I shall bring that copy. You consider that tomorrow. Then thereafter, whatever you submit regarding that recovered aspect. So probably that is the, no, Nitya Kumari, that is the unreported judgment. I've delivered a judgment. So you consider that. Thereafter, if you have anything to say, submit tomorrow. I'm keeping it tomorrow. Not today. Not today. Yes, what is 128. You are for the insurance company. So when do you want? Day after tomorrow? Let you learn it, come ready. We appear for the insurance companies as well as for claimants. Yes, record an order. 128 on the prayer of learned advocates. The matter is fixed on 17/12/2025. PM. I'm keeping it at 4 PM. Half an hour, more than half an hour is required. 4 PM. Yes. Yes. That is which case? 49, affidavit of service. 49, I have passed any order? Maybe not today only. I did not pass any order. So come tomorrow. Come tomorrow when the matter will be taken up. I have just adjourned it. In not today, affidavits are not taken. When order is passed, affidavits are taken.